To satisfy my curiosity, would you include in that if they petitioner and her husband had included their infant child in the partnership or an adolescent child in the partnership, would it also be non-dischargeable as to that partner? I'm just trying to see how far you would go with your theory.
So I think there are basically three pieces to the statutory test that this court stated in Cohen. There is the liability piece, right? You need to owe a debt, which is defined to mean a liability that's usually going to come from state law. The second is the fraudulent obtaining requirement. Money needs to be obtained by means of fraud. And then the third is you need to have the causal link, right? It needs to be a liability for the fraud. And I think candidly, I'd be surprised if state law would find a partnership in that circumstance that you're describing. But I take the point, right? I'll take the hypothetical that yes, if they're going to hold the child liable for the fraud, like actually liable for the fraud outside of bankruptcy, then yes, it would be non-dischargeable in the child's bank. I guess I don't know how to.
Well, it would be the partnership, wouldn't it?
It would be if for purposes of the hypothetical, I'll assume that you're extending, like imputing liability to all the members of the partnership. Then yes, it would be not dischargeable. And I think really the right way to think about the statute, actually, to pick up on one of your questions, Justice Kavanaugh, is to say once there's been a finding that somebody is liable for fraud, then basically just the statute gets out of the way of whatever the state remedies are available to the victim in that circumstance, and it allows the victim to get compensation, basically to get restored to the position that they would have been in but for the fraud.